I'm going to speak by narrative, if you don't mind. There is history with this council that I would like to request to disqualify Attorney Farrell.
You're telling me that the property is uninhabitable while also trying to demand to stay in the property.
Judge, I have a proposal.
Is he changing things as we go?
You cannot get ahead by talking over people.
That's the disability.
Well, no, it's not. It's foolishness.
Your mission, Ken, should you choose to accept it, is to evict this subject from your property, to augment your tactical inventory, find and engage the services of this man. He will be your closest ally. The subject will deploy countermeasures, emotional appeals, irrelevant evidence, fabricated medical conditions, and selective memory. Do not engage, do not react, record, respond only within the limits of statute, maintain composure, present verified data, execute the order, recover possession, and terminate the contract. Mission parameters complete. As always, should you or any of your team be caught, the creator of this channel will disavow any knowledge of your actions. This video will play in 5 seconds. Good luck, Ken.
And so I just real quick so I can get to deal with Ms. Johnson. Ms. Johnson, raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
All right. So listen, I've read over your motion. I do see that the original judge had given an order for you to pay in the registry. I do understand that you had certain other conditions and that it was ultimately, that may have altered your ability to do so. And then some other things occurred. Those issues, though, don't necessarily materially address the issue of possession. They're totally fine for counterclaims, but they don't address the issue of possession. Obviously, your condition would really justify you leaving the property, right? So,
may I speak?
Sure.
Okay, so as far as the position there, I did go into the property with an ADA need. I had an allergic disorder. That was addressed to the homeowner, and he said that he would make sure that there were no allergens in the home while I was there. A major allergen would be mold. That resulted from an unrepaired and unresolved and refusal to resolve without in a manner appropriately and timely. And that
Objection.
I would before.
So
Your Honor, we dismissed the claims and the counterclaims. I think we're in front of the court on a motion to enforce what she contended is an oral agreement. It has nothing to do with everything that happened before.
Your Honor, I'm not.
Well, hold on. I see an order. I see an order for continuance. I see a motion to compel rent, an order regarding such. I don't see a consent order, but I do see the motion to compel rent into the registry, which is the basis, I believe, why the writ was requested, because the $1,300 was not paid in the registry. Is that correct?
No, Your Honor.
You said no?
No, Judge, you signed an order that should be part of the record, which I can, share the screen.
Hold on. If it's been, I'm sorry, I saw them. It seems like there's been 2 judges. I see Block's been on here as well. So hold on. I see this oral agreement. But counsel, you're saying there's a different agreement? I mean, this alleged oral agreement where she's...
Judge, you signed an order. It should be in the docket. I can share the screen.
I think I had the position first. Yeah, objected. Can I go back to my position?
Just hold on. I want to see what I'm looking at first. Okay, so there's a consent agreement. That's important. And so the consent agreement indicates parties have agreed that defendant Keena Johnson and all others will vacate the property located at 2179 Diller Crossing, Tucker, Georgia, on or before September 30th at 5 p.m., and that anything left behind shall be deemed abandoned and may be removed without further order of court. Plaintiff sees anything valuable. Yeah, I feel like I remember this case. Further ordered and the judge, plaintiff's complaint, defendant's counterclaim. Yeah, so I understand. What's going on? Today's the 30th, Ms. Johnson. You signed a consent agreement. I'm not trying to be difficult with you, but there's generally no appeals, of the consent and modification and such.
Your Honor, I'm respectfully asking under my conditions for a chance to speak.
Sure.
And I'm gonna speak by narrative, if you don't mind.
Well, I would ask that you just be respectful of the time and address specifically. So hold on. Let me ask this. Why do you believe that the consent order which you signed, saying that you would vacate by the 30th and dismiss all your counterclaims, why should that essentially be not considered in lieu of your signature on such, or in lieu of the agreement that I find that you've even entered into?
Your Honor, the reason being, and before I go into that, I will say that I did ask for ADA accommodations. I am a disabled party. I asked for ADA accommodations. That was requested on August 26th. Before that, in different motions. I do not have those accommodations. Those are for hearings that are virtual.
Objection.
And so
Under one basis, Attorney Farrell, just so I can keep a record of what's going on. Objection for what?
Well, that's not the motion from the court, Your Honor. I'm objecting. The motion from the court is the motion to enforce the settlement agreement.
Your Honor, in order for me to have due process in this court, I do require ADA accommodations for cognitive disability.
Well, ma'am, are you trying to say then that you didn't have the authority to enter into the agreement that you said you had the authority to enter the agreement back on September 2nd?
No, okay, I needed, because I have a cognitive disability under stressful situations, this is why those accommodations were needed and the breaks.
Well, how do we address that accommodation? I'm not trying to be rude, but
There were a list. There were about 7 accommodations. When I'm in another county, I get an ADA coordinator that I work with. I have been asking for a DeKalb County coordinator. I've not been given that. I've been told that we had to wait on the judge to at least address the ADA accommodations. They were asked for reasonable accommodations. Those were not addressed. Those were not addressed at the last hearing. That is not what I'm saying. I'm saying for me to continue forward in the manner in which we are, I'm going to put down that I am not receiving those accommodations. I need to put that down on record. Part of those accommodations would be a support person for this hearing. Part of those accommodations will be breaks. I just got out of the ICU. My condition has been exacerbated. I've been in the ICU all week. That's another reason for the emergency continuance.
continuance for what though? And but why?
But that's why the ADA accommodations come in.
But we don't really need a hearing. And I'm not trying to be difficult, but you have to take this in consideration of how I'm viewing it. Before these things, or after these things were requested, you voluntarily entered into a consent agreement, right? Just don't cut me off. That's how you get nowhere. Why would you cut me off? That's foolish. So you've entered into this agreement on the 2nd of September, just less than 28 days ago, right? And the agreement says September 2nd, and that you vacate by the 30th of September. Stop talking. I understand your physical conditions have changed because of your health, but that does not necessarily disregard the fact that you've entered into a consent agreement indicating when you would vacate. Your ADA accommodations are not relevant because really there'd be no need for a hearing based upon the agreement that you've already entered into. So I'm trying to figure out why we need to accommodate in those regards when you've already entered into this agreement indicating that you would vacate. You've created the time to prepare to leave. That was what your plan was.
Your Honor, may I?
Yeah, you can now, yes.
Okay, so Your Honor, I've had these disabilities for years. It's not just because of this. They just been exacerbated by this. The other reason is that when I had the hearing last time, I had the hearing from a hospital bed. I had just had a stroke. I had just had, that morning of the hearing, I had just had an MRI and Xanax. I had just had a procedure. I got to the hearing late. When I got to the hearing, I was right at the point where you all were going to give a default judgment, but then I said hello, and then I proceeded from my hospital bed and my hospital gown. I didn't want to be under those same similar circumstances, under medication, and having this. What I'm saying now is that the reason that I bring this matter back to enforce is, one, because what you signed was not what we agreed to verbally, and not what was said in court. The agreement that he originally sent to me to sign was about 5 pages long. There is history with this counsel, and he did not disclose that. I did try to disclose that with you before, which may be a conflict. The history being is that we're on a similar case in another county, and that similar case it has the same similarities, health-wise, landlord-tenant-wise, but that case is confidential. The reason being here is that I just found out today that he subpoenaed He subpoenaed my medical records, and I just found that out today. I was just giving that. Let me stop. And I understand your situation, but I'm again looking at my notes from that hearing on the 2nd, and it says consent vacate by 9/30/2025. And that's about all it says. But the agreement that you signed, that he had you sign on September 10th, we have been going back and forth after the hearing. Since then, he tried to get me to sign something that was totally different language than what you said in court.
But I'm only referring to what I have in court. I
but
understand what.
for you to sign, it's not what we went over in court. That is not the agreement we made. It does not only say September 30th, get out. It does not only say.
It says the property that you'll have, and anything deemed, and you'll essentially keep a value and try to have you talk through counsel. So listen, I respect you and understand that you have certain conditions. I'd like to remind you that you're telling me that the property is uninhabitable while also trying to demand to stay in the property.
I'm not asking, Your Honor, I'm not asking to stay in the property. I've already addressed in my motions that I have signed a lease somewhere else. I have been out of the property.
But what is the issue?
The
What is the issue?
The issue is that it's uninhabitable. I cannot go in and get my property, which includes my dad's ashes, my son's autism medications, all those things.
Who can go in? Who can go in?
The property I've tried to.
Are you there right now?
When I tried to go in.
Are you there right now?
I don't live there right now, but my all our belongings are
Are
there.
you in the property right now?
What do you mean?
Are you physically in the property right now?
I am in the temporary housing property where I signed a temporary lease. I'm on my 3rd month of rent because that house is uninhabitable.
And that's fine, but that has nothing to do with ultimately you getting the remaining of your possessions out between the 2nd and today.
The agreement.
So listen, respectfully, what I do know is that you've agreed to vacate. There's nothing in here indicating that you are required to pay rent or anything like that in the consent agreement. So Attorney Farrell, I'm not sure about the writ that's been requested because I believe the writ indicates that she's missed a payment. Now, I believe that may be associated with a prior order from the prior judge about being paid in rent, but it appears that the most recent order and the most that would be effective is the consent agreement that was done on the 2nd, indicating that she'd vacate by the 30th of 2025. That's it. So whatever your writ wouldn't be signed as is currently identified because that's based on a prior order that has essentially been overtaken by the consent. So at this juncture, I would need a new writ. Ms. Johnson, what I would tell to you is that they have to submit a new writ. I do have a consent agreement where I have you under oath confirming to those terms. The end of information here.
Your Honor, I was never under oath.
And it says further ordering the judge parties will sign a mutual release and will not cover damage of any of those property defendant can. So you guys never signed that release. I see that was I guess that's the oral agreement that you guys have been referring to.
I'm trying to continue.
Paid $1,000 from her security deposit for fitting the remainder.
They added language to that consent agreement that was not part of the agreement is what I'm trying to get to.
Okay, and which part?
It's the part where they say that the $1,000 security deposit, they have, when they presented me with an agreement to sign, the release to sign in order to, there was no contingency basis, first of all, for me to sign that release in order to get that $1,000, but they put that down there. They also were supposed to, if I didn't get all my things out, given the consideration of the situation, they were also supposed to, they agreed that I would give them a forwarding address. They would allow me to get some of my most personal, valuable things back. And so they changed.
It says if plaintiff sees anything valuable. Well, that's not what it says in the order. It says if plaintiff sees anything valuable, plaintiff will reach out to the defendant through counsel to have it picked up.
No, they agreed not to pick it up, that they would give it to an alternative address. They would send it. The other thing is that
Negative, Your Honor.
So Ms. Johnson, I'll be frank. You know, I don't.
Motion today. Go ahead.
You can do what you want because that's what's legal. I'm not.
But that's not what the agreement. My argument, Your Honor, respectfully, is that there's more to it than that. That is not what the agreement was. When they tried to sign the release, they tried. The reason I bring up the other case is because the other case had language that he tried to include in this case. This case had simple language, and he gave me a 5-page thing to sign that excludes this.
I understand, but all I'm saying, Miss Johnson.
You got to give me a chance to finish under these conditions. I do. That's why the ADA accommodations were necessary. They're not because
it has nothing to do with that. I'll be frank with you. Your ADA accommodations don't justify. You're speaking fine. I'm just telling you. You don't. There's nothing that you're saying that doesn't seem as if you don't grasp what I'm saying or that you need aid. And indicating what you're telling to me is that you have an issue with this particular order. One of which I'm not quite sure because what you've already said is that what's on this order, which is 1 page, right? 1 page. So I'm not sure about what else you're talking about, but the order that I'm referring to is 1 page. And I've already read it. And it's a consent agreement.
There's one more thing, Your Honor, if you let me. On the order, when we talked about this, the security deposit, it was in lieu of the security deposit. He was not allowed to go and what he tried to put in the new agreement for me to sign in order to get the $1,000. That was cost to help me move out, not for him to move me out, but for me to be able to get my things out.
Let me just read it so I make sure that you are reading. So it says in this last portion, further ordering the judge, the parties will sign a mutual release agreement. The mutual release will not cover damage, if any, done to the property by defendant or any other occupants. When defendant Kiana has signed the mutual release, she will be paid $1,000 from her security deposit, forfeiting the remainder.
No, Your Honor. What they basically, I still have to sign their version of a release to get that $1,000. I was not able to do that because their version of that release does not state what is on that order. It actually states that I'm sorry. This is where I probably need a break, but I don't have those accommodations.
Well, how about we do that? Why don't I give you a break and I'll move on and I'll come back.
I can give you.
No. I think it would be appropriate based upon everything that you've made clear to me that it might be best for you to have a break. I'm not making an order yet. So why don't you take a break and we'll deal with the other cases.
How long will the break be?
We'll see. I'll see how long the cases will take.
Okay.
A break is better than no break.
That's fine. I did want to put out there that I would like to request to disqualify Attorney Farrell because of the conflict of interest we have. That case is without prejudice. That case is ongoing. Attorney Farrell is using some of the things in that case.
Let's take a break right now.
Okay.
All right, let's move along. And give me 1 second. Attorney Farrell, I'll deal with you shortly. Attorney Sinkway, do you have an announcement? Attorney Farrell, while we wait for the other party, did you have a response to Ms. Johnson's request and the basis of your opposing her her request for continuance?
Yes, Your Honor. I mean, really, it's a very limited issue. She's here. We're all ready to go. But in terms of disqualification, I was representing a landlord against her in a prior case. There was a confidential settlement agreement. I've not made any reference to that. So I don't know the basis of.
I object, Your Honor. He did subpoena medical records, an extensive history of records that go far beyond this case that could go into the other case, and that case is still can be revisited. And he was not privy to those same records in the last case. He did ask for discovery; those were not given. But he's used this case to subpoena my medical records, a historical amount, not just for what's going on here. And he's created a matter of controversy in order to do that by saying in his response that I could not have been in the ICU and had a visit with my primary care, which was a televisit, by the way. But he tried to say that, and then he subpoenaed her to give a history of all my medical records. That would go back to the 2024 agreement that he and I had.
Not true, Your Honor. She attached, ma'am, let me speak, please. I'll let you speak. You attached medical documents to your motion for continuance. I have a right to subpoena. I've released everyone's subpoena. I don't have any of your medical records. I don't have any of your witnesses. So that you're
that subpoena today. That subpoena was given to me at 9:45 this morning. I was unaware that he would go that far. I did try to.
Well,
I did try to present
folks. Well, let me just can I ask you for really why do you need the continuance? Let's start there.
The reason I need the continuance is because there was first of all, I just got out the hospital, but in the motion, there was in the agreement, the original agreement, there was $1,000 to assist with move out costs. It was not for them to move me out. It was so that I can get help moving out because I can't go back into that building. You just asked me, you said, how could you get help to move out? I said I couldn't do that myself under those conditions because it's uninhabitable. As soon as you walk in, you're overwhelmed with the smell. Somebody said they would charge me that amount. So I said, okay, but they would not release that to me unless I signed a contingency agreement releasing them of all future claims and all this other stuff and tons of all this stuff. And that was not what we agreed to. And that's what I'm trying to get to. But it's hard for me to vocalize that under stress, is that is not what we were getting to. They delayed giving that to me. They said, the only way you'll get that, and they wrote it in this is not what we went over in court, is if you sign this. And he tried to get me to sign a 5-page document that said, you won't do this and you won't do that and you will never do this and you will never do that. And you won't hold any of us responsible and all these other people. And that was not part of the agreement. It was a simple agreement that we just drop claims, And so now the continuance is because I haven't been able to get that amount. I do have personal items in there, even though I'm not in there, that I don't want not given back. And the reason that we decided that they would give it to me and not me pick it up is because it wasn't as easy for me to do as pick it up. If I could pick it up, I would have done it in the first place. But because I can't go in there to get those items.
Okay, so Miss, hold on. Attorney Farrell, well, I don't know if you need more time because
They released.
I understand. So just listen to me. I'm hearing what you're saying, and I'm going back to the order, and then I'm going to ask Attorney Farrell. So obviously, Attorney Farrell, you got to sign a mutual release, right? Now, obviously, because you didn't have the release provided, she's disputing the release that you provided, and it's not mutual if you guys don't come to an agreement. But basically the mutual release will not cover damage if done to the property, defendant, or any occupants. That's fine. So any future damage is not going to cover. And defendant Kiana Johnson has signed the mutual release, which will be in exchange for the release, you'll get $1,000 of your security deposit. Now that's what it said on the agreement and proposed order.
That's
You're
not what the court. Yes.
Okay. You're saying the mutual release, the $1,000 is to be paid. I assume not before the mutual release is signed, because that wouldn't make sense just to give you the money before the release, or if giving you the release, giving you the money in anticipation, knowing that you would sign the release.
What they agreed to, Your Honor, was that I would get the $1,000 within 7 days of when we left court, so that I could begin moving. That's what they agreed to. And they said it was in lieu of the security deposit. So they weren't going to be under the same statutory requirements as the security deposit, which means that they're all also asking that it be returned to condition of normal wear beyond normal wear and tear. But that goes with statutory security deposit requirements. There can't be normal wear and tear because there's already water damage. They haven't included that. They're going to try to tell me that I did the.
I don't know what they were going to try to tell you, because obviously you guys would have a mutual release.
We did not. It said in lieu of the security deposit, and
I get that.
Yes.
So, Attorney Farrell, your response.
Your Honor, we did have a little bit of a kind of a normal standard release, and then we basically reduced it to one sentence. I hereby release all of claims unconditionally against the landlord, and if you sign that, we'll give you $1,000. That's how simple there was a negotiation, and we basically catered to her and to what she wanted.
Object, Your Honor, that is untrue.
Ma'am,
with one sentence.
You can object, but folks, first off, what I don't like people is when you just object and don't file a basis. Then it's I don't know what you're making me think of whatever you claim as the basis of it. I could think of 1,000 reasons for you to object. But that's not my job. And I'm not just telling you that, Ms. Johnson. You Attorney Farrell as well. You guys are just yelling out object. Object what?
I'm sorry, Your Honor. I was never presented with a one-page release.
So
that is one line release.
So this is the issue. The issue is she's saying she can't move because you didn't supply the release that was essentially agreeable, which then you're not going to give her the $1,000. She can't get the $1,000. She's saying that impedes her ability to get. Now, that wasn't agreed to, that you were going to take this $1,000 to be able to get people to move. I understand that was your intent, but that
was the agreement. We literally said that.
So you guys don't. I understand, but most of what you're saying is about a verbal agreements that were not rendered into an order. But the judge repeated that agreement verbally in court, and then Attorney Farrell, outside of the court, drafted up an order with what he wanted instead of what was agreed to. And I understand. So really, the only issue though is your release and the $1,000. They want a writ, right? I don't think I have a problem with the writ because you agreed to. Just stop talking over me. That's your problem. You cannot get ahead by talking over people.
That's a disability.
Well, no, it's not. It's foolishness. It's not a disability. No, it's foolishness. Okay. Again, I haven't read anything about your disability, your cognitive disability. You told me that you have an issue with asthma and other allergic reactions.
They were exacerbated. I've had a cognitive.
But you're not in there anymore. So okay. So then you might need an attorney. Can you truly say that you could enter into any of these agreements voluntarily based upon your condition? Or is it just based upon how you are stressed depending upon the current situation? I'm just trying to make sure like what you're arguing, because 1 minute you're saying you don't have the capacity. And another minute.
Your Honor, if you give me a minute, I can explain. So my neuropsychologist who treats me for my TBI injuries, my history, basically he sent a letter to the other
Let's
county.
because I think about. I think
He's gonna let you.
you're not. No. But no, my time and our time.
Okay, I was trying to explain my disability. You said my capacity. It's under stressful situations. Under stressful situations. Oh,
What's so interesting? Respectfully, a litigation is what you've entered into. That's a naturally stressful situation, right? You then ask for accommodate. You can't accommodate stress. There's no way to, just listen to me. There's no way to accommodate for the stress of litigation. There just isn't, other than having a representative. You don't have a representative.
I've asked for one.
There are no public defenders for this type of matter, unless you go out and get one. You're not talking, and so unless you go get a designated representative, somebody that could do that. You've had the opportunity to do that. You've entered agreements by yourself. So I'm just want to make note of that on the record of what you've done thus far, and now what you're bringing to the court's attention, as well also arguing for yourself. You're literally, at least to the court, you're picking and choosing when you want to necessarily allege. That's just what it looks like. So I just respectfully, I just want to understand Attorney Farrell. You guys haven't been able to reach a mutual agreement for the $1,000. How do you plan on resolving that?
Judge, we have the $1,000 ready for her today. It's a one sentence, a release that she'd have to sign.
And Ms. Johnson, what's your response to that?
Your Honor, what do I do with the $1,000 if I have till 5 o'clock and you've had me in court till 2? Do you understand? And just to get back to on the record, what we discussed about my disability is that I have had reasonable accommodations in another court, in another county. And there are reasonable accommodations where I can speak for myself with those accommodations in place. And that is under Title II of the ADA Act. And so courts are supposed to give reasonable accommodations, or at least say why they're not going to allow that.
But you're not telling me what you really need.
I did. I sent a motion.
No, tell me. I understand, but you're in an oral motion hearing right now.
I've already.
No, don't tell me what you've already. Just tell me now. Why is that so difficult?
So that would mean breaks. That would mean a support person. That would mean note taking. That would mean I could answer more than just yes or no. That would mean there's a list of things. Right now, this is a stressful time for me to go over that list. I haven't been given those accommodations, and I didn't just pick and choose. I asked for those accommodations prior to the first hearing ever. I asked for those accommodations. I didn't just pick and choose. I entered into the first hearing I entered into the first hearing letting you know that my condition was exacerbated. Not that I didn't have this pre-existing condition, but it was exacerbated and that I needed those accommodations. So I didn't pick and choose. And I don't pick and choose when my disability would become an issue either. But I
just don't recall. Just be honest with me, and I'll be honest with you.
That is honesty.
When we entered into this agreement on the 2nd, honestly, when I got you under oath, and you,
it wasn't under oath. I came in late. I never raised my hand.
I don't enter into these agreements without having people go under oath. But if you were never, I can check my record.
Check your records. I never went under oath. Would you like to agree to that? I never went under oath.
Attorney Farrell, was she placed up?
I don't remember your.
Oh, see, I thought you were shaking your.
No one remembers, but I did enter late from my hospital bed. Never did this.
Ms. Johnson, I think what you misunderstand is that what we have is a consent agreement that when you say that we spoke and we talked, so I know we spoke. I know we talked about the terms and I put everybody under oath.
And those were not the terms.
So stop talking over me. My God.
Sorry.
What is wrong with you? I know what's wrong with you, but you
disability.
Well, I'm not going to hold your disability against you, but what I will find is that you're entitled to the $1,000, but you've got to sign the release. Now, if you don't want to sign the release, then you're not entitled to the $1,000. Now, I'll be frank. Stop talking over me because I'm not going to say it again. Now, if I'm going to look at this objectively, the truth is that the writ of possession could still be issued despite the fact of the $1,000 not being issued. Now, that just means that you don't release their claims and you can pursue them independently for whatever claim that you so choose. The $1,000 that I see here doesn't specifically indicate that your $1,000 was specifically used to have somebody go in and remove and retrieve your possessions. That's not what it says, nor do I recall that was ever being the basis. If that's what you're saying, that was the communication in the hopes that you would accomplish, I understand that. But that obviously didn't happen. And just because the parties don't reach an agreement on the mutual release doesn't indicate that you weren't necessarily agreeing to vacate by the 30th. Now, if you guys want to appeal that and essentially address that issue, that's totally fine. But what I cannot get over, Ms. Johnson, is that there was a consent order that has been signed by the court that you're not disputing necessarily the terms, other than the fact that not the terms of the consent order, you're disputing the terms of the mutual release.
Your Honor, I'm disputing more than that, because there was not supposed to be any type of beyond normal wear and tear. That's on the consent agreement as well, because there are issues already in the home past normal wear and tear. There was a whole water damage issue.
So then that just means, again, you guys need to address the release. The release is the issue, not the writ of possession. The longer you stay out of, and this is the part that is of difficulty, the longer you essentially contend to have possession of the property, there's still damages done to them. I understand that you're saying that you have damage by virtue of not getting the property, but this is an ongoing situation. So every day that it is continued, the damages for them increase. That is the weird nature of the landlord-tenant matter. I'm unfamiliar with your counterclaims, if any, that have been addressed. And if anything, they would have been based on this agreement, essentially been released, right? And so all I'm saying to you is that if you want to rehash the case and you're trying to overtake, I don't have enough to say that the consent agreement should not be honored. I don't have enough, not based upon what I've seen today. But what I do have is I do see that a prong of the consent agreement has not been fulfilled because the parties have not been able to reach agreement on the mutual release, because that's the prong that seems to be as of issue. And so, Attorney Farrell, you're saying you're going to give them the money. I haven't seen the release. I'm not your attorney. Since you don't have an attorney, since you didn't go out and somebody isn't there for you to speak for you, I don't know. I only have you. So based upon, you're saying that someone was supposed to be supplied, and if there's an attorney that was supposed to be supplied, I don't know.
Your Honor, weeks ago, the agreement was a time frame where we left that hearing. I was supposed to get that money and be able to move out with that money.
I just can't imagine you would get the money without the release. They're not going to get
the reason that it did not get signed. The reason one of the reasons that we are here today is because Attorney Farrell decided to draft a release that had nothing to do with what we agreed upon or what you said we agreed upon. It had nothing to do with that. He added extra language, and that extra language was not what we agreed upon. And so to make me have to sign a release that we didn't agree upon in court, and he's saying that now it's a one-line release, but I've never seen that. He doesn't state what that line is to you so that we can confirm what that is. And here we are, September 30th. And
Ms. Johnson, I cannot be your lawyer, respectfully.
I'm not.
I know, but in many ways, what you're essentially arguing with the court to do it, you're asking for, listen, this is the part, this is the problem that I don't understand. Continuing the case for what? For him to get a release that you may or may not accept. I don't have authority to demand him to give $1,000 to you.
I put in my motion the reason for the continuance. You have not addressed that reason at all.
Which is
the fact that I just got out of the ICU. My condition has been exacerbated. This release, and I'm adding to this, is that the fact that I only asked for time to be able to, I'm asking you now, currently, for time, and it doesn't matter if it's a week, it doesn't matter if it's 7 more days, just time to be able to, if they do agree, if we do get that $1,000, if we do move forward, that I have time to have someone at least come in and get those things. That's it. I am not in the property because it's uninhabitable. My counterclaim is not even in this jurisdiction. It's over $15,000. I've already spent a higher amount just staying in hotels.
So Attorney Farrell, what is your position on the issue of the release not being mutual, yet not being agreed to, and $1,000? Because I mean, I understand you can't force her to sign, and Ms. Johnson, you have to determine what you want to do, because if that's something that's not signed, then I'll be frank.
You want me to
I
sign
want you
something
to-
that is not, that's
But I
you want
can't
me to,
tell you whether or not it's in your benefit. or
I have a simple solution, maybe. And my client is here, by the way, Your Honor. He's Mr. Thomas.
Yeah.
Yes,
Ken
yes, I'm
Thomas.
here. I'm here, Your Honor.
Yes.
And you,
Well, Mr. Thomas, I haven't gotten you under oath, so let me just hear from Attorney Farrell.
sure.
Well, Judge, we could just modify your order and just say the parties. I mean, it kind of says that anyway, but basically we could just make it simple that all the parties. I mean, the order read that the complaint was dismissed with prejudice and the counterclaims were dismissed with prejudice. So, and then everything left beyond September 30th was deemed abandoned, except that my client would notify her if there were things in the property that she may want. They definitely didn't agree to transport any items for her, but we could just basically, I could amend the agreement that'll have a language that says the parties release all claims against each other related to this particular property, except the condition of the property. You know, if the property is been damaged, my client doesn't. Yes, but
I object. That exception does not include the fact that it was already damaged.
So this is the problem, Ms. Johnson. I can look at it in the sense that you guys have a consent order and one of the terms have not been addressed. And so we can leave that open. I think that that's still a way to address it because possession becomes problematic, Ms. Johnson, just honestly, that if I allow you the case to continue on and there's no other agreement, you guys are not intending to take possession, that obviously has a continued harm on the defendant when it was the intent for you to be out by the 30th of today, at the end of the day. Obviously, you're saying all of that was based upon you getting money from, based on a release. Now, you don't want to sign the release because
I don't want to.
you don't want to sign the one that they presented to you. That's a fact. That's what you repeated over and over again.
Because those terms are not what we agreed to.
But there are no specific terms, and I understand.
We gave a whole 5
But
pages.
in the specific order, there is no specific terms that are laid out other than saying it'll be a mutual release. There was no actual release identified. This happens a lot. I'll be frank. This happens a lot in civil cases. People don't get paid for months because they can't agree on releases. So it happens. You're not entitled for it to happen quickly. That's a fact. And no, it is frustrating your goals, but that's the fact. So if you guys can't get that signed and redressed, obviously that would impact the remaining portion of the agreement because you don't have a full, everything has not been completed. And so Attorney Farrell, unless you guys can come up with something else, Ms. Johnson, it's hard for me to acknowledge that you'd have to get out and you leave all your stuff when you don't have the ability to get in, but it happens to a lot of people. So I'm not trying to be difficult to you. A lot of people does not just listen to me. Just because you have ADA issues and accommodations doesn't give you the basis to, particularly when you don't have like a subsidized rent or anything justified that you'd be able to stay in the property or to be able to delay the process any further than what you have. And so,
may I?
Sure.
Okay, Your Honor, if the original argument, and we're not going to try to relitigate the case, but the original argument is that the property was uninhabitable. I couldn't stay there. When you originally started this case, when you originally came on, you said if there was a condition where it was uninhabitable, then that would be a reason not to pay rent. Also, rent was stopped. They agreed in July. They sent me.
Well, I'll be frank, Ms. Johnson, You're now relitigating facts. I'm not hearing any facts. We're hearing on a motion that basically we're based on a consent order. So this is what I'm going to do. Attorney Farrell, how do y'all plan on getting her the money? And I guess, again, you're not forced for her to sign just anything. I don't think, Ms. Johnson, you understand that a release has to be agreed to. And if you guys don't agree on the release, then the money isn't given. But then that means you retain all your rights. That's the harsh part, because I know for you, sometimes your rights don't seem as valuable as the $1,000 part.
When you say my rights, could you elaborate?
What I mean is you're saying that you're relinquishing, you're dismissing your claims. That was the part that seems like there's a problem, that you're dismissing all your claims and you're not going to do that.
Sign the release.
Right. And I'm saying, but then you have the ability to not sign that portion. It doesn't mean that the writ doesn't get issued, but you don't have to sign that and you don't have to take the money. And then you have all of your counterclaims and things that you would desire would potentially stay in play because you never signed the release.
Your Honor, one thing I wanted to ask, the agreement originally was there would be no writ. The September 30th was the last day of the lease. So there's no need for a writ. It's the last day of the lease.
But if you haven't vacated, there would be a need for the writ.
Well,
Well,
in
no,
order is- sorry.
Well, go ahead, Attorney Farrell. I'm sorry. Maybe I misstated.
No, I mean, the order states that anything left beyond the 30th would be deemed abandoned. Well, can I ask Ms. Johnson one question, Your Honor?
Sure.
All right. Ms. Johnson, if you got the $1,000, how quickly could you get your stuff out of the house?
I could try to get somebody to help me get it out within a week. Hopefully.
See, there's that hopefully.
I mean, but if I couldn't do it, let's just say 10 days. If I couldn't do it within 10 days, then we would continue with abandonment. But what we did agree upon, and I just want to revisit that, is the fact that the valuable items. So there are things in there like my father's ashes, my son's autism stuff.
You can't get any of these things when you have these folks come and get your stuff.
But-
No, you personally.
No, when people come, if I had 10 days to do it, yes, that's what I would do. I would try to get the most out, and then everything else would be abandoned. That's all I'm saying. But it wasn't what
So Attorney Farrell, let's stop.
Yeah.
So we don't need to hear anything else from you. Attorney Farrell, what's your position on that?
My Mr. Thomas is here, and
Mr. Thomas, you unmute and raise your right hand. Swear, affirm, and tell the truth under penalty and perjury of the law.
I do.
All right.
Your Honor, all I have to say is simply, you said it perfectly. We are hemorrhaging money because we're not getting paid rent, and not for just 1 month. But we said, don't pay us anything. Just go.
I take it you guys have not done the walkthrough.
He wouldn't let us.
Your Honor, that's not.
She wouldn't let us.
Your Honor,
I can't get in my place, Your Honor.
Stop.
we repeated in court, and you asked. If you were the same judge that was in court, you asked Mr. Farrell. You said, "What is $1,000 on?" He said, "Is it because of the security deposit walking?" He was like, "No, it's just $1,000," and he just kept repeating what it was for. And you kept mentioning a walkthrough, and it was in lieu. He kept saying it's in lieu of the security deposit and the statutory requirements that come with it. He also wrote that in an email to me, and in an agreement, he tried to get me to mutual release. So that whole statutory requirement where there's a walkthrough and there's this, that, and the other that comes with security
There's no statutory requirement per se that you have to have the walkthrough. There's statutory requirement that they have to send you notice of what the alleged damages are and what they're deducting. But I guess again, you guys, it's not that you guys are wasting time. It's that ultimately what we have is we had agreement. A portion of it was not executed. And so now you're saying we want to blow it all up. When I'm saying, I'm looking at the terms of the agreement that can be exercised because it doesn't seem as if there was a time period identified on the release. Now I know that cuts back.
that it would that it would be $1,000 given within 7 days is what he stated in court.
I don't recall. And
Well, I was in the hospital, and there are witnesses that do recall.
but those witnesses, even if you do have witnesses there, the record would be the best thing.
The record.
If you don't want me to do the following, because there's a strong position that I can look at this thing and say, honestly, neither one of you have done what you're supposed to do. Now, if you're saying that she has blocked your ability to do the walkthrough and you've not, and she just is not willing to, because if you, Ms. Johnson, you don't have you have the authority to not sign the release. I think that's the part that you're not getting. You don't have to sign the release. Signing the release only gets you $1,000. So that isn't necessarily essential to the terms of this agreement. That's if you only sign it. So everything else isn't necessary, isn't predicated on you signing this release. That's the part that I think I want you to understand. The release is totally separate. The walkthrough is its separate portion, as well as you vacating is a separate portion, right? So you need to be out by 9:30 and 5 p.m. That's not going to happen, more than likely. So that means they probably request a writ. Now, you were supposed to also do a walkthrough, right? And you'll dismiss all your counterclaims. And you will not defending any of the counterclaims and attach damage beyond a normal wear and tear. Well, that was if you
Liberty
did.
Mutual.
Yeah, but that's if you guys were to do a walkthrough.
Liberty Mutual.
But you guys, I don't see the word Liberty Mutual, but I don't see that in here. The only thing I see is that, you'd vacate, and if you vacate, by that time, you're essentially releasing all your counterclaims, and then you'd sign a release by releasing all your counterclaims, and you get $1,000 from your security deposit.
Of the hearing.
Judge, just to be clear though, the counterclaims are already dismissed. You already signed an order, and the claims are dismissed. To be fair, so that part's a fait accompli.
No, object.
Y'all just be saying object. I almost don't want y'all to use the word, because if y'all not going to have a basis behind object, don't say object. If you don't have a basis and don't lay a basis for the objection, just saying objection is just noise to me. So you give me a reason why you're objecting before you just say object. This isn't like a deposition, or you just get. But let me do this. I'm gonna let you take another break. I'm gonna send y'all to the breakout room. Maybe y'all can talk and figure it out, because I've got other cases to get to. And so it really is between y'all. If I make a decision, you're not going to like what I'm going to do, but I'll give you guys another opportunity to see if you guys can resolve amongst yourself.
Your Honor, I appreciate that. Greatly appreciate it. But she has proven to me, if not this court, that she cannot be trusted.
Well, who knows?
No need to go.
Next time, listen. Next time, let's be quiet. Next time, I'm just going to have everybody sign. And you can guys do it as an electronic document, and everybody will sign it. In council, you'll have all the documents done. We won't have to worry about another document being produced later. Because basically what you guys did is you guys went to did a mediation, and now you guys are coming back saying, Judge, we haven't really reached an agreement. And that stuff happens all the time, Ms. Johnson. So that means you guys really don't have an agreement. That means we could have a trial. Now, that would be the way I could do it. I could say, you've got to consent. Neither party has consented to the terms and agreed. And then we can have a trial.
When would the trial begin if we did?
I guess instead of a continuance, I'd reset it for trial, because we haven't been able to address all the other matters in the consent agreement. Attorney Farrell, what's your position on that?
I would respectfully disagree, Your Honor, about that.
Okay.
It should be a trial.
I would agree with trial.
And Attorney Farrell, what's your basis as far as the parties not essentially performing all of the agreed terms in the consent agreement? What's your position on that?
I guess you could have a motion to enforce agreement. That would be, if Ms. Johnson can say, well, I'm willing to sign it, but you're not giving me the $1,000. That would be an option that she would have. I don't think we can blow up the whole thing though and say, go back to square one and have a trial.
No, I listen, I'm generally agreeing, but I'm trying to determine what terms are you saying that they didn't do. But it comes back on you, Ms. Johnson. I'll be frank, it really comes back in your plate. If they give you a release that you don't want to sign, then you don't have to sign it until you're comfortable. Or you can have somebody who's a lawyer that reviews it and says that you're comfortable. But you don't get to push back. You don't get to agree, but the problem then becomes you don't get to sit on the house too.
I understand that, but
so why don't you take a break and think about what you want to do, and I'll deal with other people's cases.
I just wanted to ask you a question before I do that. If we were to go to trial, because you mentioned,
I don't think we will. I just was a thought, but when I think about it time and time again, because this is produced and I'm trying to give you an order today because I really don't want to continue it, is that I'll be frank, 9/30 is the date. Whether or not you sign the release and release all your claims is a decision of your own. I know you're saying that there's an order where there's dismissed, but there's not a mutual release. So I don't know exactly what counter thing. I mean, that's usually dismissed. I don't really know if I signed it with prejudice, but obviously claims that wouldn't be applicable here could still be arguably alleged at another time. So the money is only if you do the walkthrough and agree with everything.
More than just the money,
but I know it's more than just the money to you. I mean, but so why don't you pause? Because I have a strong feeling about what I want to do. But why don't you pause? Think about it. Attorney Green, what do you have?
Judge, I have a proposal. I know it's not what you asked me, but we're willing to give her the money tomorrow. I mean, it's because it's already 3:00 today. I don't think I can get it to her today, when we can deliver it to wherever she's at. And then we'll give her an extra 7 days from tomorrow. And then we could put her in a court order, and it could agreed upon by everyone in court today. Simple. Landlord releases all claims against the tenant, and the tenant releases all claims against the landlord pending walkthrough.
This is what I want you to do. Ms. Johnson, what do you have to say to that?
You said pending walkthrough. So if we get through the walkthrough and both parties disagree, then what?
Well, it could be you may have put the place on fire, so they can't release. Well, they don't know what the condition of the property is right now, and you could start a fire there tonight. So pending walkthrough, that's Georgia law, where there's a claim that could be asserted against a tenant afterwards. That's kind of what Georgia law is. The security deposit statute contemplates.
So neither one of us would release claims until after the walkthrough.
No, that's not the way I said it. And my client's willing to release. You talked about water claims. They said they'll release the claims, including any water claims. That's what you talked about in front of Judge Joshua Davis here a little while ago.
Guess I'm sorry, Your Honor. If you're keeping up, is he changing things as we go? Because from what I understood, the first thing he said was it's simple, and then he continued to say other things after the fact. So I'm just trying to figure out what it is. Initially, you said it was just simple, and you had two sentences, and then when I repeat those, you make other claims, and that's what the problem is here.
Ma'am, ma'am, let me talk. When you ask me a question, I'm sorry. I'll let the judge be the judge.
All right. So, Ms. Johnson, he's offering that you would essentially have an additional 7 days for him to get you the money, and they would do the walkthrough in between that time. Now, if you guys, for some reason, don't do any of those things, then there are consequences to that. There has to be consequences. Otherwise, nobody would agree to anything. So what would the consequence be? I guess, Ms. Johnson, so just so we're clear, he's offering to give more time and hopefully give you money for the release. Now, if you don't, I tell you before, you do not have to sign the release, but then you don't have to get the money either. So that's a fact. That is not something that's a fact. So you have to make the decision on what's more important to you. Because the court, I'm not going to allow you to remain in the property permanently until you guys come up with an agreement. After a certain amount of time has passed, right, then I'm just going to issue a writ, right? Because ultimately the terms were that you were to vacate for various, for whatever reasons. So they're offering to give more time to get you this money. I can't tell you whether or not you're going to agree to everything in the release, and I can't tell you guys are going to agree with everything in the walkthrough. That's in the future. I can't tell you. And he can't agree to that either. Agreements in the future, to some degree, are illegal. Because you like to say for it to ever occur, like saying dismiss claims that ever occur or maybe occur out of this particular claim, that might be more reasonable. But to say they ever occur, it wouldn't be applicable. That's not the kind of release that would be applicable. But
yes, that's right. That's what he wrote initially.
Well, and I don't know. I haven't seen it. So you telling me is of no value to me. So you guys can I would just, I don't know, suggest maybe you guys get her signature on it. Maybe that way you don't get to come back, Ms. Johnson, and say you didn't agree with whatever said. And Attorney Farrell, if you produce a release, I don't know. I don't know how those terms would be made to make her feel comfortable, because I'll be frank. People send me releases, and if I don't like them, I don't sign them, but I don't get the money. So that, Ms. Johnson, what you're asking for, you can't have it both ways.
Now, Your Honor, I just want to put on the record that you are denying, just on the record, you denied my ADA accommodations. Is that correct? I'm not denying. I looked at your accommodations, and pretty much all of them have been met, but for having a person here, and you have not either identified who you'd want or what program that you'd get them through. So I would deny that. And I would say that that's not the case looking at your motion. You've had time, you've had breaks. This is over Zoom. You're not in a condition that I would argue would be more stressful than a position where you have a bunch of people around you. So I don't necessarily believe that the accommodations that you see in the base of how we've been moving have not been met. But would there be a copy of the record? You'd have to request it. But at this juncture, well, I think you'd have to request it early, but you can always make that motion. You can make. You didn't mention. Ms. Johnson. No, no. Listen to me. I'm not going to spend any more time. So listen, one last time before I do what I'm going to do. He's made the offer to get you additional 7 days to get you this money, okay? And to be able to get your release. No, I'm going to speak, and then I'm going to make an order. I'm going to give you this last option. That's what he's saying. Do you want to do that or not? I just want to ask a question about the option. Yes or no? I wanted to ask a question about the option. You can address it to Attorney Farrell, not me. Attorney Farrell. Okay, so in regards to the option, you said you would get the $1,000 to me by tomorrow. And then you said 7 days, and then we would do a walkthrough. I don't know how I'm going to do that going into that house the way it is, but a walkthrough. So that's another health risk. We would do a walkthrough, and based on what we see during the walkthrough is whether or not we release claims, future claims. Is that what you're saying?
What I originally said was, I was trying to make it very simple. You release all claims against the landlord releases all claims against you pending walkthrough. And then,
So only the landlord gets an option to have an exception.
that's right. And the reason is because you have his property and you could be destroying the property. He doesn't have anything of yours. That's why it's different. You're not in the same position. And then in 7 days, during that 7 day, you get your money tomorrow. In those 7 days, you can get your people to come and take out of the property whatever you want, and then the landlord gets the property back.
And those are the conditions without an additional release.
The release is just what I said. You said it was too complicated. I've made it very simple. You release all claims against the landlord. The landlord releases all claims against you pending walkthrough, and the landlord, and I'm adding more to it. I know you didn't like that last time, but it's for your benefit. That release also includes the water damage, because you said that before, that was something that the landlord could hold against you. And Mr. Thomas is here and he's saying he's not going to hold that against you.
That's right.
And that will be in the writing in the release.
Yes, ma'am. And I could have it, we could make it part of the judge's order if you like, if the judge would agree to that. We could do it right, and you don't have to sign anything. It would be part of the judge's order.
And then okay, because I was just looking at how would we do the walkthrough if I could not go into the property without risking my health?
Zoom.
You could have a proxy,
FaceTime.
a substitute,
Your son.
or you could. I guess
Yep.
Mr. Thomas is offering to do a walk. You know, he could do FaceTime or some kind of electronic ways you could do it.
And I just based on what the Judge Davis mentioned, we wouldn't enter an agreement. The agreement would be, it would not be based on future claims. It would be based on this right here, the current claims.
My position is you've already released the claims based on the dismissal with prejudice of your counterclaims. But having said that, so everyone has closure, you're releasing any other claims that you have, and then the landlord's releasing any other claims he has, and then the case is wrapped up, and hopefully you go about your life and you never interact with each other again.
Yeah, but those claims are contingent on current. We're not going into the future. That means it's from today back, current.
I just want to say something real quick, and then I'll let Attorney Farrell talk. You voiced the concern in front of the judge here in the court and everyone that you didn't want a walkthrough, or you didn't feel like that was fair because you felt like we may try to come back and blame you for the water damages. As my attorney just said, we're willing to stay here in court and the judge can put it into the document. We're not trying to get you for the water damage. Everything excluding water damages or anything in reference to the water damages, totally absolved. I'm saying if we go in there and you, I don't know, did any other damage, who knows? Other damages to the properties that could exceed a lot of money. I think it's only fair that we do a walkthrough and have a look at the property. That's it.
I also think it would have been only fair that you would not let mold and anything build up, and you would have done the repairs in time. But you chose not to.
Well, now we're rehashing. So do we have a deal going forward? Now we're rehashing.
We're not rehashing.
Okay, well, that's our offer.
You chose to be a retaliatory landlord, not accept my rent. I was not late. You just didn't accept it. You decided there was no rent due. I sent that document.
Ms. Johnson, this is like yesterday's news, yesterday's weather. We're way past that. We're going forward. Right. So real simple. You said I sent you a 5-page agreement. Your point has been well taken. You've been heard. We're keeping it super simple. You release all claims against the landlord. Simple as that. Landlord releases all claims against you pending walkthrough. That's right. The release includes water damage. We'll get you $1,000 within By tomorrow?
The
You
release
tell me
does
what-
not include future claims.
No, it doesn't include future claims.
It does not include.
You all are not going to have future. I mean,
I'm sorry. I'm sorry.
This is what I'm going to do. Listen. This is simple. I'm going to grant your continuance for 7 days. If you guys don't work it out, there'll be an immediate writ of possession on that 7 days regardless. So you'll come back and see me on Tuesday or you won't. When you come back on Tuesday, if you haven't done what you have done, then it'll be a writ because possession of the premises has nothing to do with you collecting the remaining portion of the money. Quiet.
I agree
Stop.
to the terms.
It doesn't, okay, because that's what it's going to be. So it's either that or that. But guess what? His terms don't matter until the order is signed by both of you. Whatever you guys got going on, when it got your signature on it and his signature on it. Otherwise,
You can have that today?
be quiet to me. Be
Okay.
quiet. And then next week, you either will appear, right? Or I'll see your order in my inbox for me to sign. And if I haven't signed it, you're going to come back to court. It's going to be virtual. So there won't be any issue for you there. And then we'll address whether or not you guys have gotten any money and signed anything. If you haven't, then I'm going to just give a writ because we granted
For
your
a trial?
continuance. For a writ of possession.
Okay.
And then that'll be it. And you can disagree and you can do whatever you want to.
No, I'm not.
But that'll be the order. I will see you guys next Tuesday. Next Tuesday. Hopefully you guys get it addressed.
OCGA 44751.
Thank you.
Thank you, Your Honor. Thank you, Your Honor.
You're welcome. All right. You guys are free to go. Hopefully you guys can get everything in.
I object to OCGA.
I would recommend, Attorney Farrell, if you guys have any new agreements that are entered into, that they have her signature as well. So they won't be.
4751.
All right, ma'am. But that's what it'll be.
Trial.
Thank you.
Thank you, Your Honor. Have a good evening.
You're welcome.
we're excused, just to be clear.
Yeah, please. And again, like I said, if you guys do anything, make sure that it's signed by both parties. And I will see you guys both on next Tuesday anyway, just to confirm that everything's done so we can have full conclusion of the case. So Ms. Johnson, you would have gotten your continuance as agreed. But again, that continuance will not address the issues where you've already signed on a consent to be vacated by 9/30. We're just continuing it on because of the issue about the signing of the mutual release of $1,000, which I still don't think is relevant to possession at this juncture, based upon the reading of the consent. But based upon the totality of the statements made today and the offers that have been made by counsel, then we're ultimately going to see you guys on next Tuesday. But if no agreement is made, possession will be granted to them based upon everything else that's already in the record. All right? So
Okay.
I'll see you guys next Tuesday.
Thank you.
Well,
Thank you.
yes, you reach out to me. Thank you.
Yes, ma'am.
See you. All right, Attorney Sinkway.